Okay, today is March 28, 2012. This is Children in Justice, and you had your midterm examination last week. We just went over that examination, and we are actually on Learning Module 6 now. You were required to complete Learning Module 5 at or about the time of the midterm. So we didn't discuss that in class. It was not on your midterm. It will be on your final. Let's jump right into Learning Module 5 and see how far we get this evening. Your readings included Professor Meyer's text, Chapter 4, as well as an article on the Margaret Kelly Michaels case and a video that describes ideal child maltreatment investigative practice. That's Learning Module 5. You'll also see at the top of the Learning Module the objectives. And when I posted on the announcement page about good study habits, I suggested that a good place to start are those objectives. Because if that's what the professor in any class thinks is important, and they took the time to write that down, to say this is what the student ought to get out of this, then they probably are going to put some of that on the exam, or at least the issues that are raised by those concepts on the examination. Anyway, back to Professor Meyer's Chapter 4 in his textbook. That is a chapter on investigative interviewing regarding child maltreatment. Okay? And actually, before we begin that, I'm going to open this video clip here. And while I'm not going to go through everything, I'm going to address some of the issues in a good investigation of a child abuse case, physical or sexual, focus being primarily on sexual. Obviously, you needed to watch this. You need to watch it again in contemplation of the final exam if you want to study good. I'm not going to touch on everything in this. This is for you to consume on the web, but I'm going to touch on some of the highlights of it. First of all, we're talking about investigating a crime upon a child. And the difficulty with crimes on children is that they're kids. They don't control their own destiny. They present challenges in expressing themselves and communicating to adults. They are completely and utterly deferential to their parents and controlled by their parents and subject to their parents. That's what makes these kinds of cases so challenging, and that's why we have mandatory reporting. In part, is because these crimes on children occur in a secret place, and that is the family home. They occur in private. They occur with the shades drawn and the doors closed. They occur in a context where there is not any kind of scrutiny by other people. Nobody is watching other than the parents, and the parents, by definition, are the potential criminals here. So they're very difficult to investigate and prosecute. There are issues that present themselves that are unique to this class of cases. You don't see them in robberies or murders or terroristic threats or any other kind of criminal investigative practice. So we're going to look at some of the issues that I would suggest to you make for a good child abuse investigation. Now, you see a slide up there that says the fresh complaint. The fresh complaint. In every child abuse case that involves sexual abuse, sometimes physical abuse, but where it involves sexual abuse, you want to speak to the person that the child confided in or the child told about their victimization that brought it to the attention of the authorities, and anyone else that the child confided in. Let me contrast that with what the legal concept of fresh complaint is. Fresh complaint is an evidence rule that goes back 100 years or more. And it really has nothing to do with child abuse and is all about the rape of an adult woman. Many, many years ago, the legal experts, the professors of law and the academics who looked at these kind of cases realized that women who are raped don't always report right away. And if they don't report right away, sometimes they might confide in someone that's close to them about being raped. So it became permissible to introduce evidence by an adult rape victim that shortly after the rape, they confided in somebody about the rape. For example, if a woman was raped in the back of Pathmark at 3 o'clock in the morning at one of these all-night grocery stores, and she didn't go to the police that morning, and she didn't go to the police that weekend. In fact, she didn't go to the police for a month. When she goes to the police 30 days later, she could file a complaint. Even in 1952, there could have been a prosecution for rape. And even in 1952, probably going back to the late 19th century, there was the potential for that rape victim to introduce fresh complaint evidence. And that is evidence that shortly after she was raped in the Pathmark parking lot, she told her sister what happened, or she told her mother, or she told her best girlfriend, a confidant, someone that a victim would typically turn to discuss private affairs. That would be evidence to rebut the suggestion that she made it up at a later date for some other reason, to take out the sting of the delayed disclosure or the delayed reporting. Because it would be very hard to get a conviction and very hard for a jury to consider back then this rape victim believable if they didn't report it right away. So the law allowed the fresh complaint of a rape victim to be admitted in court. However, it was very rigorous. You couldn't put the sister or the mother or the fresh complaint on the witness stand to say exactly what the victim said. They could only take the stand and go, yes, it was a Wednesday night, my sister came home crying and upset, her clothes were disheveled, and she told me about something terrible that happened where a man attacked her sexually in the back of Pathmark. Stop. That's the end of it. How it happened, what he was wearing, how he held her down, the specifics of what happened would not be admissible. But that would be important stuff. What is allowed in is important and helpful. The sister can come in and say, yeah, my sister came home, she was all messed up, and she told me some guy attacked her. That helps build up. It's to rehabilitate her credibility because the jury might assume she's lying because she waited 30 days. It has to be fresh. If she told her sister 20 days later, court wouldn't let it in. It has to be shortly after the assault. Now, what shortly after means, over the years, courts have made it a little bit more expansive, but it's typically within hours, maybe a day or two of the rape. Now, courts in 2012 have really expanded what fresh means, how soon after. But for most of the time, it was within a day or two. That's not what we're talking about with child abuse. Although that could happen if the child went to someone shortly after the abuse, or even a long time after the abuse. With kids, that's an example in 2012 of the courts really expanding the time limit. You might be able to get in what they said. Not the details, but the fact that they complained. But we're not talking about that in an investigative interview. What we mean by a fresh complaint in an investigative interview is anyone the child told other than the authorities about being molested. Anyone. Their mother, their counselor, their teacher, their little playmate. One way to think about it that is perhaps more accurate is a prior complaint witness. They told someone in the past being any time before the day the cops open the case. Any time before there's the authorities involved. So if we got a case today on the 28th of March, and the little girl's here, was there a time you told someone else about this? The day before yesterday, I told little Mary, my playmate, fresh complaint witness. Did you tell someone else? And last year I told my teacher, but she didn't do anything about it. What's her name? Jane Doe, fresh complaint witness. And then I tried to tell my mommy the year before, and she said, don't worry, I'll keep you safe and make sure it doesn't come in your room. Fresh complaint witness. Anybody the child told other than the cops and the social workers who are investigating the case, is a fresh complaint witness or a prior complaint witness. In our unit meeting today, this issue came up. We're investigating a case where an adult now reports being sexually assaulted when they were 7 years old. They're now, I don't even know, 20-something, maybe 30 years old, I forget. But they're well into adulthood. And one of the issues in the case is that the accused, who's a relative, a family member, the man who molested this person, is accused of molesting this person many years ago when the person was 7. That man went to a lawyer and went to the police and claimed that the victim and his family were harassing them. So there's a record apparently out there of him saying, they're out to get me. So it's not a good case when somebody comes in and goes, oh, I was molested by my uncle, and makes a report about that to the police. And the police find out that this guy has gone to the cops in the past. He didn't go to the cops, he went to a lawyer. He went to the lawyer in the past and said, listen, these people are harassing me, they're out to get me. So, preemptively, well before he tells the authorities that he was molested, he reports that well before the boy tells, now adult, tells the authorities that he was molested, the accused goes and tells his lawyer that they're out to get me. So that makes what he says today a little suspect. This is consistent with his prior report that they're out to get me. So the day we pick him up, we go, I told you, this is what they're resorting to? They're accusing me of child abuse? It's exactly what I was telling my lawyer. Now, whether that wins the day, whether there's other evidence, who knows? But it's not a good thing. As a prosecutor, I don't want to hear that. If a lawyer comes in and officer of the court goes, yeah, I got notes from 2010 where he was at wit's end because they were out to get him. They were falsely accusing him of all kind of things. Well, we have a witness that says, now he never reported this alleged victim. 7 years old, 8 years old, 9 years old, 10 years old, now he's 30, whatever he is. He never reports it. But he has confided in people. Most of the people he confided in the past 3 months. So that's not helpful, because this guy claims 2 years ago, this family started harassing me. But one witness, one person in 2009, his ex-girlfriend, he told her that his uncle abused him when he was little. That would be a fresh complaint witness. And in this case, it would be an important one, right? Because it predates the assertion that he's being harassed or they're out to get him, or there was some falling out. In the typical case, though, let's get rid of the harassment. Supposing he says, you know, that's because, it actually was 5 years ago. Because I was telling my detectives, I go, listen, we need to get her in. Because if she comes in and says, yeah, you know, I was going out with him, we're broken up now, but I got no bad blood towards him, you know, I got no ill will. Yeah, I thought it was tragic that he told me that his uncle molested him. He really didn't get into the details, but he told me as a little boy, his uncle molested him in the bedroom. And that's why, you know, at times he gets angry and is anxious or whatever. However, he presented it to her in 2009. It actually was 5 years ago. What would that be? 2007. If that's true, if we get that fresh complaint statement, that prior complaint statement, as I told my detectives, anything for the past 5 years that might have been between the accused and the victim would not impact our case. Supposing the accused says, hey man, they're out to get me because you know, I told them I'm going to report them for tax evasion in 2011. Yeah? If they had a fight or a falling, I loaned them $1,000 in 2010. And they won't pay me back, so now they're trying to get from under that debt. Any assertion that there was motive to falsely accuse him that developed in the past 5 years is out the window because we got a lady who he confided in 2007. So if the defense is trying to say he made this up because, you know, they're mad at me because I wouldn't invest in their restaurant, and they gave me $5,000 to open my own restaurant, and they say I didn't pay them back on time. In fact, they said they're going to sue me for that money. That's why they made this up. Sir, when did all this happen? Last year. We got a witness. So if that's the basis for this false accusation, we got a witness from 2007 that says the guy made a prior report about this. So that takes away any allegation that this is fabricated based on some conflict among the parties over the past 5 years. And that's good. There are a lot of ways that fresh complaint witnesses help us. One of them is what I just told you. In the law, they call that to rebut an assertion, of recent fabrication. Now, you take those fancy words apart. You can bring in what someone confided in another in the past. In the case of child sexual abuse, that the victim told someone in the past to rebut, to address an assertion that there is a recent fabrication, that they made it up recently. I didn't do any of this. She's making it up because of this, because I took her bike away, because I wouldn't go to a party, because I owe them money, because I wouldn't help them cheat on their taxes. That's why they're making it up against me. I am asserting that they're fabricating this. That's what the defense would be doing. I'm asserting that they're making this up to get me. Well, you could bring in a prior statement that's consistent with what they're saying, that they were molested, that predates the alleged fabrication, to show that the fabrication is not the motive at all. That's one reason you might introduce a fresh complaint. But in the world of child abuse, the fresh complaint is more important, I would say, at the very least equally important, because the fresh complaint gives us a window into the credibility of the accusation. And what I mean by that is, one of the things that troubled me when I first took this job, when I first began prosecuting people for sexually molesting kids and physically abusing them as well, I said, man, what if I'm wrong? Okay, that's okay. I don't think that's going to happen then. Maybe it will. One of the things that I had to grapple with was, what if I'm wrong? These are such terrible accusations, and someone can go to jail for a real long time, and the facts are so murky in these kind of cases. I truly struggled with, how do I know I'm doing the right thing? There are a lot of ways to think about that and to feel good about what you're doing, besides what I'm about to say. But one of the things I thought about was, if I'm confident that what the allegation is true, then I'd be in a much better position psychologically to deal with these cases. And the way that I looked at whether I believe this case or not is not so much how the victim presents now or what they have to say. That's important, and I would look at that too. But I always wanted to know, how did they come out? What made them tell? And who did they tell? And how did they tell? Because in 99% of these cases, they're delayed disclosures. The thing happened a while ago, and they're telling us today. And I say, why today? What happened to make them come forward today? If they were molested and it stopped 5 years ago, why not year 4, 3, 2? Why today? And there's almost always a reason. There's almost always a motive. In the case I just described to you at the meeting today, the detective really didn't get a very good answer to that. He goes, well, he had had enough. He thought it was the right time. That's what he said, but you need to press a little further. There's something there that we don't know about. Now, it doesn't have to be evidential. It might not even be that interesting or that important. It might be as simple as, I watched a program about it, and it made me think about what happened to me, and I saw a victim on a TV that was able to deal with a lot of her problems simply by getting it out. So that made me decide, I need to get this out. Or, I have nightmares my whole life. I think maybe if I get this out, the nightmares will stop. Whatever. There's something there that I don't know about the motive for telling today. But it's not only the motive for telling today, and when you're dealing with small children, you may not even be able to get into what their particular motive was on that day, sometimes. But what's equally important is how they told. What was the context of their telling? Who was there? What words did they use? How did they express themselves? What was their demeanor? Their affect? By demeanor and affect, we mean what was their behavior like? How did they look? What was their emotional state? And if the way in which it came out makes sense, then to me it's credible. If the way in which it came out doesn't make sense, or seems to be illegitimate or suspect, then we have to take a very close look at what the allegation is. But the fresh complaint witness is a critical witness. It gives us insight into a lot of things here. And particularly, it gives us insight into whether this whole case has the feel of truth, whether it feels credible, whether the way in which it came out makes sense. Okay. The other thing that the fresh complaint witness does is inform us about how the interview might go later on. And in forensic interviewing, that's real important. If the child said, "I don't want to get my mommy in trouble," when she told the guidance counselor about what happened, I'd like to know that before one of the interviewers walks into the interview room. How the child told and what the reaction was to that child will help the interviewer down the road. So if if the person who got the information, let's say the school nurse says, "Are you sure? Because Uncle Manny could go to jail if you're wrong." Not a good thing to say. It's true. The person who got the information might be truly concerned about that, but the message is bad and has the capacity to undermine our ability to get a disclosure, to interview that child objectively. But we want to know that. We're not here to judge the school nurse. We just want to know if that happened. If that happened, we're going to have a kid who feels one way about telling. Right? If something else happened, then we have a kid that feels another way about telling. So whether the person who heard the information was judgmental, whether they asked the child additional questions, whether they were skeptical or surprised, or injected shame or embarrassment or disbelieving, all that stuff is important to know for the next step in the investigation when we interview the child. We want to know how that kid feels about telling. And how they feel about telling is not only a result of their own personal emotions surrounding when they told, but it is also influenced by how the people responded to what the kid said. And very few people respond completely neutrally and completely supportive. But how judgmental they were, how disbelieving they were, how skeptical they were, how excited they were. Oh my God, your Uncle Manny? Are you sure? Kids get the message loud and clear based on their behavior. And people react all kinds of different ways when you hear something like this for the first time. You want to know that. You want to know that before you interview the kid. You also want to know how they told, what the kid's behavior was, what their emotions were, to size up the credibility of the disclosure. So the fresh complaint is real important. That's something that's bread and butter in child abuse investigations. What is this? Guess they're putting ads on my videos now, huh? I need a cut. Come on, man.
Yeah, they need some help, I'll tell you that, after Italy. I'm not watching that.
Well, once you interview the fresh complaint witness, you have to obviously interview the child, and you have to do a competent forensic interview with the child. We'll talk about investigative interviewing in a moment. But you got to do an investigative interview with the child. You got to interview these fresh complaint witnesses. One of the things that's critical to a competent investigation of any case, including child maltreatment, is controlling the flow of information. Controlling the flow of information. And in child abuse, because of all the challenges that I led off with about families and secrecy, and it happens when the kid's alone in their own homes, with the perpetrator or someone they love and respect, and very often their own parents, you need to respond immediately. Tomorrow's too late. Tomorrow's too late. You need to respond immediately, and you need to manage and control the flow of information. So if at 10 o'clock in the morning a child discloses to a guidance counselor, by 1 o'clock in the afternoon that child needs to be in a cell. They need to be interviewed by somebody. And then the suspect, the non-offending caregiver, maybe the mother, the siblings, the fresh complaint witness, all of these people need to be interviewed right away and spoken to. Because if that child goes home or too much time elapses, there is a significant peril that develops. And that peril involves the parents influencing the child, the non-offending parent, the siblings, or anybody else, telling that child what to say or do, or simply by judging that child or acting inappropriately around that child. And more importantly, the suspect finding out. And it is equally advantageous to interview and interrogate the suspect before he knows what's going on. And I use he because most of them are he's. You need to interview that suspect before he knows what's going on. Forewarned is forearmed. Many, if not the majority of people we interview and interrogate confess. But those statistics change dramatically if they know what's happening and they sleep on it and they come the next day. They will not talk to you. More likely than not, they will exercise, as is their right, their Sixth Amendment right to counsel. If they exercise their right to counsel, they will not talk to us. It is critical that we seize them and interview them before they know what's going on. It's simply a fact. So immediate response is important. You want to get the suspect before he knows what's going on. You want to interview the child before the mother or other people can influence that child, and before the child gets the true message about the potential that this case has, what might happen in their life. And if you wait till tomorrow, it's too late. You need to keep people separate. You can never interview people in the same room. These shows on television make me laugh, where people are interviewed in the same room. Witnesses need to be segregated. They need to be separated and need to be interviewed individually, and they need to be interviewed at the same time. You don't want to interview critical witness 1, send her home, and then interview critical witness 2 the next day. Especially in a modern age like this, where people use cell phones and text messaging and Facebook. They will communicate exactly what happened in the original interview, so the next witness will have been tainted and corrupted, and you will not get objective information from that witness. Now, can you do it always? No. There are situations where you can't control. You have many witnesses. But ideally, you interview all witnesses at or about the same time, separated from one another. You stand the greatest chance of getting quality, objective, truthful information. But to this day, when schools don't report child abuse right away, principals bring in the kids, they put them in a room, 4 girls. So you say the lunch monitor, The lunch monitor touched you on your butt? Who did he touch first? He touched me first. No, he touched me first. Boom. That's not a way to interview anybody. And the response of one person influences the recollection of other people. Just a fact. Whether directly or indirectly, whether consciously or subconsciously. Now, in law enforcement, we know better, hopefully, and we would never do that. But it still happens. So you need to manage the control of information. You need to respond immediately. You need to separate witnesses. You need to have spoken to the fresh complaint so that you interview the child and address whatever emotional issues she has about the process, about telling what happened, about telling her mother or her aunt or whoever she confided in. You need to talk to those people so we can appreciate how that kid is processing all of this so we can do a more effective interview. Obviously, you have to interview the child. You have to interview the witnesses. Now, if you watch that video, I go over all this stuff in detail about the investigative interview. I'm going to move on to Myers chapter 4 here, investigative interviewing in child maltreatment. And he describes in chapter 4 how the defense lawyers, whether it be civil or criminal, had a tough time in dealing with child sexual abuse cases. In the early days of these prosecutions, the defense attorneys really didn't know how to address kids in the courtroom. They found their traditional methods of cross-examination didn't translate well when they were cross-examining small children. Getting in someone's face, asking confusing questions, pointing out their prior inconsistent statements, banging on the table, being aggressive and assertive did not have a lot of jury appeal. The last thing as a defense lawyer you wanted to do was alienate the jury because you're beating up on a little kid. Even if you truly believe the allegations were false or fabricated or erroneous or mistaken, the last thing you want to do as a defense lawyer was to be perceived as bullying a child on the witness stand. And it was difficult because they didn't know any other way of cross-examining. Now, a good defense lawyer, even back in the day, could adjust their tone, their demeanor, and their approach. But kids were different. Even when they adjusted it with an adult or a grown-up. Okay? They still wanted to catch the grown-up or point out that they're mistaken or wrong or demonstrate that their memory's bad or that they're inadequate in some way. You're not going to win a lot of points showing that a kid's inadequate. So they struggled with this kind of stuff. They struggled with figuring out how to cross-examine. So they realized that you can't attack the child. What could you do? Well, eventually they realized you could attack the interviewer. When these cases that you addressed in your discussion board, McMartin, Kelly Michaels, Little Rascals, Fell Acres, when these institutional abuse cases came down, and there was serious doubt about the credibility, the believability, the truth of the accusations, when law enforcement and child protection were exposed as doing poor interviews, the defense began to realize that they could still defend these cases without beating up the child. And that's what Professor Myers is talking about when he says the shift has moved towards an attack on the interviewer. So the defense didn't have to attack the child anymore. They now attack the interviewer. They could explain to a jury, listen, ladies and gentlemen, Danielle took the stand in this courtroom and she really believed something happened. It didn't. My client didn't do any of these things. Now, Danielle told you about what happened, and some of the things she said were rather believable. She's just a child. It's not her fault. None of these things ever happened. The reason why Danielle was able to tell you these things is because they were planted in her mind by the interviewers, by the DIPUS workers, by the detectives who spoke to her, and by the prosecutor's interviewer. None of this happened. My client sits here innocent. And the prosecutor is asking that you put him in jail for something he didn't do. And if you think about it, the only reason he's here is because of the lousy interviews that happened in this case. We heard in this very courtroom that bad questions can influence kids' memories, can influence their recollections, and that's what happened with Danielle. She believes some of these things happened because of the terrible interviews that the government did in this case. They went out of their way to ask questions over and over again, to give this child gifts, toys, when they answered the way they expected. So now, you could attack the interview and say the child's okay, they didn't do anything wrong. And that empowered the defense. And they're good arguments, they're legitimate. So the focus changed from the attack on the child to the attack on the interviewer. And the remedy for that, the answer to that, is to do better interviews. If that is a legitimate argument, and if we have the potential to do lousy interviews, then we ought to do better interviews. We ought to learn how to interview kids in a forensically defensible way. So the antidote to the defense argument that the interviews were lousy, the kid is okay, she's just telling us what the interviewers influenced her about. But the interviews were horrible, they were misleading, and they led to a false accusation. The antidote to that is doing better interviews and doing forensically defensible interviews and showing that good practice was used. Good investigative practice. And that's what Myers talks about in Chapter 4. About how to do better interviews of kids. Because the attack is on the interview now, what should we know about investigative interviews? Well, you need to know how children remember stuff, what their memory capacity is. If you take forensic interviewing, you'll learn more about this. But kids have the capacity to remember large amounts of information. Even preschoolers have good memories. The difficulty is expressing themselves. One of the maxims, one of the sayings in child maltreatment that drives this point home, I think, rather effectively is, children know more than they can tell. And that's true. When they experience an event, even a preschooler, it's encoded. It's in their memory banks. It's remembered, but it's hard to retrieve and hard to express. That's the challenge of real little kids. And our challenge is to try to tap into that, to try to help them retrieve it, and to try to help them express it in a developmentally appropriate way that is forensically defensible. Professor Myers talks about two kinds of memory, actually 4 kinds. Free recall. Free recall is simply, tell me what happened today. It doesn't use cues or prompts. A cue is, tell me what happened when you parked the car in the parking lot and the man started yelling. That would be recognition memory or cued recall. They're very similar. The question cues you about what the questioner is interested in hearing about. And that kind of question can result in more information. It's a little less reliable, but you get more information, especially from kids. Cued recall or recognition memory. Myers presents them as 2 separate concepts, but they're very related. Recognition memory is the kind of memory that is operative when prompts or cues or reminders are involved. Free recall is simply tell me about what happened today, where you go back in your memory banks and report everything you can remember. Or tell me everything that happened today at school. That still calls for free recall. You are not asked about a very specific area of your school day or aspect of your school day. You're not given any context. And in giving you that context, it sometimes can help you remember stuff. Recognition memory is kind of easy to remember. It's the kind of memory that is jogged or cued by the use of a prop or a cue, which could be a thing. You know, if I show you a tattered briefcase and that helps you remember something, that could be a cue. If I tell you, well, it was raining that day, does that help you remember? Yes, I do remember now. Now that you tell me it was raining, this happened or that happened. I remember it now. So a question or information provided by an interviewer can act as a cue, right? You don't need to see something physical. It could be a word or a statement. Cues, C-U-E, cues take us back to time and place. And they could be physical, could be an object, it could be a word, it could be a smell. Anything that's presented to our senses might help us remember. Where free recall is simply tell me about what happened at school. Now, in the world of child abuse, one way that we tap into recognition memory is through the use of a prop that helps the child remember, allows them to demonstrate better what happened, and takes them back in place and time. What prop do you think I'm referring to that helps kids tell what happened to them that we use in child abuse cases? Anatomical dolls. Anatomical dolls. That taps into recognition memory. Tell me everything that happened when Daddy took you in the attic. Asks for free recall, right? And if the child's describing how he pushed her up against the dresser and made her hang on the handle and then can't explain exactly where his body was or what he did next, by using the dolls to demonstrate body positioning, it could take the child back to time and place and help them remember more details of what happened. It helps tap into recognition memory. Detectives have exploited this to get more information for hundreds and hundreds of years. Hundreds of years. When they take a victim somewhere to help them remember better. Where might they take a victim? Of a robbery or a rape or a shooting? To the place that it happened, or the scene of the crime. That kind of process taps into the victim's recognition memory. So that process, when you take a victim to where the crime happened, the smell, the building, the earth under her feet, all of her senses are stimulated in some way and may contribute to her remembering more details. Any one of a myriad of sensory stimulus could help her remember more details about the crime and act as cues and tap into recognition memory. Free recall and recognition memory. Here's perhaps a way to understand this on the exam perhaps is recognition memories because you recognize something. I recognize the scene, it helps me remember. I recognize the battered briefcase, it helps me remember. Recognition memory is when something helps you recognize what happened in the past and helps you remember. Okay? The next memory that Myers talks about is scripted memory. And that happens in child abuse cases. That happens in child abuse cases where there's repetitive abuse, where things happen the same way all the time. The way that memory works with scripted memory is they may not remember a distinct incident. If they were molested 4 or 5 days a week for 2 or 3 years in their bedroom, it happened nearly the same way, all the time, in the same place. The human memory doesn't encode those events separately because they're repetitive. They call it script memory because you're testifying how it usually happens rather than how any distinct incident happened. It's like a script. That's why they call it script memory. Like a movie script or television script. Right? One example in our lives is you brush your teeth. You do it every day at or about the same time, multiple times. Right? Can you separate any time you brushed your teeth last week from any other time you brushed your teeth on Monday, Tuesday, or Wednesday? No. It's something that you do routinely and regularly, and you really can't tease one out from the other. Sadly, these kids get molested in nearly the same way every night. So when we say, how did it happen, or we ask them for specifics, they can only tell us how it usually happened. Now, among those times, there may be times that are different subtly. They just won't be encoded. If one day he used a condom and he never used a condom before, that one might be encoded. When there is a material deviation in the script, that deviation might be encoded. By encoded means it might stick and they might be able to retrieve it. That is scripted memory. Professor Myers talks about recovered or repressed memories. We're not going to discuss that. That is a controversial area. I believe there's some merit to people suppressing recollections. We know that people, to deal with stress, block out bad memories. Whether they are blocked out in fact and irrevocably, that is, you don't know that something happened, you can never retrieve it. It is so buried in your recollection that it's irretrievable and absent to you, is controversial. And then you recover it. It's one thing to know about something traumatic and block it out. Never think about it. There's things, happened in my life I don't think about, man. We may all have something that we just don't think about. But if you force me to think about it, it's there. I got to go retrieve it. It's going to be hard and I don't want to do it. But if I think about it, I'll find it. It might be hazier because I have suppressed it. But it's there. Recovered memories suggest that it's been blocked out and like it never happened. That part of your memory is deleted. You don't know it. And through some therapy or some event, it's recovered. Something happens and it jogs that memory. It rustles it up and it comes back to you when it was forgotten completely. That's out there. Something to think about. Not the kind of stuff that prosecutors want to go to court with, or even civil lawyers. Because the quantum of proof, the amount of persuasiveness that you need in the courtroom is significant. And to have somebody go, well, now, I didn't know it happened, but now I know it happened. It was there and I recovered it. And unless there's corroboration, it's a tough sell. But for therapy, and maybe even for child protection, that needs to be followed up on. Go ahead.
Regarding the example you gave earlier today about the man who was almost 30 years old and reported about what happened to him in 7, do cases like this crop up often, and do they always? How often are they prosecuted? Does it depend on how ironclad the evidence is and the? Because it seems like it seems like in a hierarchy of resources available to prosecute cases of child abuse, that prosecuting one of a person who's 30 years old now might be less important than stuff that's going on right now.
Yeah, well, you look at these cases, you get a lot of them now. There's a lot of public awareness. People are more comfortable, relatively so, in reporting these cases than they were years ago. So you have greater public awareness, a more accepting institutional culture where the police and prosecutors and child protection and therapy, embrace you, when in the past you may have been rejected. So the environment is better to report. There's more public awareness, and the statute of limitations was abolished in New Jersey. Up until 10 years ago, 20 years ago, they could not be prosecuted because there was a statute of limitations. So we're getting more of these cases for the reasons I just said in law enforcement. You look at them all individually, and it doesn't have to be ironclad. I would judge this kind of case like any other case. Do I think I can prove it beyond a reasonable doubt? And if I can, if the guy's alive, he's dangerous to kids. In some ways, I'm in a better situation that now that the person's older and has full command of language, has full command of their recollection, and can express themselves well. I'll take a 29-year-old who says they were molested between 7 and 12 over a 16-year-old who says the same thing closer in time to when it happened. Any day. Because of all the skepticism about teenage girls and boys, but girls are in a tougher position. We've talked about that. Sometimes we joke around and say, you know what? We're never going to win this case with this teenage girl. We'd like to tell her, listen, come back when you're 25. Juries will embrace you. Juries will be more forgiving, more understanding, and find you more credible as a 25-year-old than as a 16-year-old. Just a fact. Just a fact. And we're more successful with older witnesses. Now, if they have issues in their past, or they're not an effective witness, or they are vulnerable on cross-examination, then no matter what age they are, then they're vulnerable. But all things being equal, give me the adult. So you would look at what happened in the past and size it up and go forward. I'm looking at this case and judging whether it's winnable. Not because we want to win, but because we want to allocate those scarce resources that you're talking about. The accused in this case is, only 40-something. I mean, he's got access to kids. If he has a sexual preference for children, it's still out there. We need to incapacitate him as much now as we would if this kid told when he was 11. So you need to look at the facts and decide whether you think that the case is prosecutable beyond a reasonable doubt. And if it is, whether you're going to go forward. One of the things that's different about child abuse with children versus an adult who reports is that the adult has greater influence over whether I would file charges. The 11-year-old who says, I don't want you to prosecute my daddy, he's not going to carry much weight with me. None of them want us to prosecute their daddy. And they're not mature enough to evaluate the issues involved. If a 29-year-old says, I ain't coming to court, I'm not going to hold her in contempt and put her in jail or threaten her with jail to get her to testify. Now, there may be a case where the ends justify the means, and we might have to rattle our saber a bit, try to encourage them to come forward and pressure an adult victim. But the adult victim has a lot more influence over prosecutorial involvement than the child. And in the case I was talking about, I want to hear how that man feels about this case going forward. I have to assume that he wants to go forward. He reported it. But we'll see. We'll see. Any other questions? Memories fade. Adults' memory fade. Kids forget faster than adults. Not much, but the rate of forgetting is more significant for small children than it is for adults. Okay? Something Myers talks about. Stress and memory. Well, the jury's out on stress. There's some who believe that stress enhances memory. Some believe that stress degrades memory. There is some research, though, that supports the fact that there is greater resistance to suggestion when we're questioning someone about a stressful event. And it's one area where it all depends, whether stress enhances or degrades. So Myers tells us, in summary, kids have a good capacity to remember stuff. They remember things in a variety of different ways, and they express it through free recall. They express it through recognition memory, scripted memory, cued memory, which is really recognition memory, some of the things we just talked about. The next section is suggestibility, and we're not going to talk about that today. We'll talk about that in the next class. And that is the potential for kids' memories to be influenced by the kinds of questions that the interviewer asks. Okay? At least that's the most typical way that we evaluate suggestibility and think about suggestibility. Kids' memories can be influenced by lots of things, not only the questions that interviewers ask. But the questions and the manner in which we question children is front and center when we evaluate suggestibility. And that was a lot of what the Margaret Kelly Michaels case was about, and Nick Martin. There was a lot of concern over suggestibility there. We're not going to spend a lot of time on it because that's for forensic interviewing, but we'll touch upon it. And we'll look more closely at investigative interviewing next week. Any questions? Okay, if you have any, just post them to the Cyber Cafe.